Hey everyone, welcome to this explainer on Intro to Contract Law. If you're a first-year law office study student or just grinding through your 1L year, you are in the exact right place. I'm creating this explainer specifically as a student for students because we're all in this together. You are my study buddy. Before we jump in, please hit that like and subscribe button to join our ultimate study group. We've got a lot of ground to cover, so let's get right into it.
Here's the game plan for today to help you crush those 1L exams. First, we'll look at the roots of contracts. Then, track down our legal sources so you know which rulebook to use. After that, we'll master the heavy contract taxonomy vocabulary, look at enforceability, and finally, apply it all to some real-world case law.
All right, Section 1, the roots of contracts, defining the core. Let's figure out what a contract actually is and, where it came from.
So, here is your black-letter law definition straight from the Restatement of Contracts. Yeah, it reads a little circular, right? But boil it down, and a contract is fundamentally just a legally enforceable promise. And the historical context here is actually pretty fascinating. Back in primitive societies in feudal Europe, your duties were totally locked in by your birth status. But as modern capitalism boomed, contract law kind of replaced that rigid caste system. It gave people the actual freedom to order their own lives through mutual assent. It was a pretty massive shift for society. Moving right along to Section 2, sources of contract law. Basically, where do the rules come from? Because as future lawyers, we absolutely need to know which rulebook to open up when things go sideways.
Okay, mental snapshot time. This comparison is a classic 1L exam cheat sheet. Contract law basically comes from two main buckets. If your deal involves real estate or services, like, say, plumbing or drafting documents, you're going to use judge-made common law. But if you're dealing with the sale of goods, like physical movable things, you've got to apply the Uniform Commercial Code, or the UCC. They actually created the UCC because dealing with 50 different state laws for commercial deals was just a total nightmare for interstate business.
And hey, definitely file this one away for your final exams. If you're looking at an international contract for the sale of goods, watch out for the CISG, the Convention on Contracts for the International Sale of Goods. Adopted by over 40 countries, including the US, it functions kind of like an international UCC. In fact, it actually preempts the UCC in international commercial agreements. That is a trick question waiting to happen right there.
All right, Section 3, the contract taxonomy. This is our high-yield vocabulary section where we categorize these agreements based on explicitness, mutuality, and enforceability.
First up, explicitness. An express contract is exactly what it sounds like. The terms are spelled out directly, whether you wrote them down or just said them out loud. Like, I'll buy your car for $5,000. That's express. But an implied contract, specifically implied in fact, is inferred entirely from the parties' actions. Think about walking into a deli and ordering a turkey sandwich to go. You didn't formally negotiate the price out loud, but by ordering the food, your conduct implies a contract to pay for it.
Then we have the highly testable quasi-contract. Now this one is implied in law, not fact. It's not a true agreement at all. It's actually a legal fiction created by the courts to stop injustice. Picture this. A local lumberyard mistakenly drops off a load of wood at your house instead of your neighbor's. You don't say a word, you just happily use it to build your deck. Even though you never struck a deal with them, a court will impose a quasi-contract forcing you to pay for the materials, just so you aren't unjustly enriched.
Now check out the flow of the exchange here. A bilateral contract is all about mutual promises. Party A promises to pay, and Party B promises to wash the car. Both sides are a promisor and a promisee. But a unilateral contract, that exchanges a promise for an action. If you staple a $50 reward poster to a telephone pole for your lost dog, you're making a promise that only gets accepted when someone actually performs the action of bringing the dog back to you.
Moving to Section 4, enforceability and completion. Let's talk about the terminology around binding the deal.
You absolutely have to nail the difference between void and voidable. A void contract is missing a core legal element, meaning it was literally never a contract to begin with. Think of an agreement to commit a crime for cash. Neither party can enforce that in court. A voidable contract, on the other hand, is a perfectly valid contract that a protected party can just choose to annul. Like if a 17-year-old buys a car, they're a minor. They have the legal right to void the deal and return everything to the status quo.
Now, what happens if an agreement is technically unenforceable? Maybe it lacks traditional consideration. Well, that's where the equitable doctrine of promissory estoppel steps in to save the day. If someone makes a promise they should reasonably expect will induce action, and you actually rely on it to your detriment, the court can make that promise binding just to avoid a totally unfair outcome. Basically, contract law protects agreements, but promissory estoppel protects reliance.
We also classify contracts by their timeline. If a contract is executory, it just means the promises are still pending. They haven't been carried out yet. But once both sides have fully performed their obligations, the wheat has been delivered and the cash has been handed over, boom, the contract is considered fully executed.
Okay, quick study buddy tip. I highly recommend memorizing this list of legal suffixes. In English legal terminology, the OR ending means the person taking the action or making the promise, right? Like the offerer or promisor. The double E ending is the recipient, the offeree or the promisee. Seriously, train your eyes and ears to catch these suffixes now. It'll save you a massive headache when exams roll around.
All right, home stretch. Section 5, Real-World Case Law. Let's apply all these rules and see how this taxonomy actually works in court.
Let's look at the Rogers Backhoe Service case. So a funeral director hires a company to demo a foundation. Out of nowhere, the city mandates they explore a subterranean sewer system. The contractor goes ahead and does the exploratory digging. But later, the owner refuses to pay, claiming he never explicitly agreed to that extra work. Well, the court wasn't having it. They found an implied in fact contract. Why? Because those services were absolutely necessary to keep the project moving, which conferred a clear, beneficial service to the defendant.
Next up is South Trust Bank v. Williams. The bank mailed out an amendment to its checking account customers adding a binding arbitration clause. Naturally, customers sued, arguing, hey, we never expressly assented to this new material term. But the court explained neutrally that these at-will checking accounts operate as unilateral contracts. Simply by continuing to use their checking accounts after getting the notice, the customers implicitly assented through their actions.
Finally, we have the Woolley case out of New Jersey regarding at-will employment. An employee was fired without cause, even though the company's personnel manual detailed a very specific procedure for terminations. The employee tried to argue that the manual was just company philosophy, but the court ruled neutrally that voluntarily distributing a personnel policy manual acts as an offer for a unilateral contract, and an employee accepts that offer simply by showing up and continuing to work.
So, if we zoom out for a second, contract law successfully moved humanity from a rigid birth status system into one of choice and mutual agreement. It's a real game changer, which leaves us with a pretty provocative thought. As our modern society, technology, and global economy continue to evolve at lightning speed, what entirely new forms are our legally binding agreements gonna take next?
And just like that, you survived our explainer on Intro to Contracts. Since you are my absolute favorite study buddy, and we are totally in this law school journey together, please hit that like and subscribe button. Keep reviewing these slides, keep studying hard, and I will see you right back here in our next study session.